So my talk today is called Canada Summer Jobs, the Good, the Bad, and the New Blasphemy. Now obviously that's a play on the old classic film, The Good, the Bad, and the Ugly. I've never seen it, but I'm aware of it. And the ugly here is the new blasphemy, and I'll get to that in a few moments. So as Anne mentioned, I'm going to talk about two specific cases involving the Canada Summer Jobs Program to highlight some of the good that came out of that litigation, some of the bad that came out of that litigation, and to point to the new blasphemy, which is the ugly of all of that. So as I'm sure most of you are aware of what the Canada Summer Jobs Program is, but just in case, here's a sort of 30-second history and definition. So the Canada Summer Jobs Program is essentially a grant program that the Stephen Harper government created in the early 2000s. And its purpose is to provide grants in the form of funding to employers in order to promote the hiring of students for employment during the summer. Now in 2018, the Canada Summer Jobs Program became the focus of national controversy in Canada, and Chris referred to the attestation issue. And that is exactly what I'm referring to. So in 2018, the Trudeau government introduced a new eligibility requirement for employers seeking funding. And that was that they had to make a certain attestation attesting that the core mandate of the organization seeking the grant respected charter rights. And it defined charter rights as to include abortion rights, or right to abortion. Now, obviously, that was a problem for a lot of organizations, particularly pro-life organizations, but even non-expressly or openly pro-life organizations were caught in the middle of this. So a lot of churches, a lot of summer Bible camps, a lot of private Christian schools or evangelistic ministries felt that they were unable to make that attestation because the core mandate of their organization did not respect or promote the right to abortion. In fact, it said that that was a awful thing. So as a result, several Christian organizations chose not to apply for funding that year. A number of Christian organizations chose to apply and check the box, make the attestation. And then another number of Christian organizations chose to apply, but to scratch out the abortion attestation. And some of them attached a document saying, we can't make that attestation and here's why. So all of those that struck out the abortion attestation or didn't check it were refused funding, and their applications were denied and rejected. And a number of those organizations brought legal action against the government for the rejection of their application. I had a number of clients that did that, including a Christian university, Redeemer University, based in Ancaster, just outside of Hamilton. There were also two other Christian organizations, and I also represented four private for-profit corporations. So I represented a cement company, a tool and die company, a specialty lumber company, and a trailer sales dealer. And their position was, we're in the business of making concrete. We're not in the business of taking sides on a political or a moral, philosophical issue. You are compelling us to take a political position or take an opinion that we otherwise would not take. And by checking this box, we're alienating a third of our potential clients. And so we don't want to do that. Now, unfortunately, none of the clients I represented had their day in court, because there was another organization, a pro-life advocacy group, that had also commenced legal proceedings, and they had started their proceedings before anyone else did. And so as a result, the government moved or asked the court to suspend the other cases until the first case was heard and decided. And the court granted that request. So all of these other cases kind of died a quiet death. But I'll get back to that case in a minute. First, I want to talk about the 2019 program. So as a result of the controversy, the government backed down on the abortion attestation and replaced it with a new human rights-related attestation. And specifically, any employer seeking funding had to attest to the fact that they provided a workplace free of harassment and discrimination. And so again, in 2019, Redeemer University applied, and they checked the box because they don't discriminate in their hiring. And then after a few weeks or a few months, they got a response from the government saying, you have failed to demonstrate that you provide a workplace free of harassment and discrimination. You've got 10 days to provide documentation demonstrating that you do, otherwise you'll be deemed ineligible. So in response, Redeemer University sent in their 35-page anti-harassment and discrimination policy. And because Redeemer is a Reformed Christian university, its policy had Reformed Christian language. So the anti-harassment policy and anti-discrimination policy had things along the lines of, we believe that all are created in the image of God and therefore are worthy of dignity and respect, and we therefore will not permit discrimination on any basis. That being said, we are a openly Christian community, and we will maintain our Christian character, identity, and our Christian integrity. So they sent that into the government, and then a few more weeks or months went by, and eventually they were told that they were disqualified and their application was rejected. Now, the thing about the Canada Summer Jobs Program is they don't give you reasons, they don't explain why you've been rejected or disqualified if they reject and disqualify you. So Redeemer started calling around, they contacted their member of parliament, and they kind of got wind that they were rejected because of their view on marriage and sexual morality. So we challenged that decision in court, and through the litigation came to confirm that the basis of the government's rejection was 3 documents. One was a academic calendar from, I think, 2013 or 2014. One was a student handbook from, I don't remember the year, but it might have been 2015 or 2016. So these were dated documents. And the third was an article in a online newspaper called Religion News Service. And the article was about Trinity Western University and its campaign to start a law school. And there was one paragraph about Redeemer University and how Redeemer University had a similar code of conduct. And of course, it's not called a code of conduct, but it is, for all intents and purposes, a code of conduct. And so it was confirmed through the litigation that that was the basis of the rejection. And ultimately, we won in that case, and the court found that the decision to reject Redeemer's Canada Summer Jobs application for 2019 was problematic. We won primarily on procedural fairness grounds because the government didn't give Redeemer the opportunity to respond to its concerns or to demonstrate that it did not, in fact, discriminate, which it doesn't and did not. So when you fill out the Canada Summer Jobs Program, you have to identify if you're going to prioritize certain groups in your hiring. And in its application, Redeemer did say that it would prioritize people from marginalized communities, including people from the LGBT community. So the government concluded that Redeemer discriminated against people from the LGBT community, when in fact they were going to prioritize their hiring from that community. But they never gave us an opportunity to respond or explain that. They never gave us an opportunity to demonstrate that although there is a code of conduct that students and faculty and other key senior positions are required to abide by, those summer students hired for a part-time job over the course of 4 months were not required to abide by it. And they also didn't give us the opportunity to demonstrate and argue that if we did limit our hiring to people who abided by our statement of faith and code of conduct, that was not unlawful discrimination. So in Ontario, we have the Ontario Human Rights Code. Every province has similar human rights legislation, and all of those, each one of those provinces' human rights legislation prohibits discrimination on certain grounds, including sexual orientation. In Ontario, as in all other provinces, though, there is an exception carved out for certain organizations, including religious organizations. So I'm now speaking to you from the Metropolitan Bible Church. It would not be inappropriate and it would not be discriminatory for the Metropolitan Bible Church to require some of its ministry leaders to abide by its statement of faith and to subscribe to the theology and doctrinal positions that the Metropolitan Bible Church adheres to and teaches. That is not discrimination, that is association. So what Redeemer University does by creating this Reformed Christian community of students, faculty members, and other staff members, it excludes certain people that don't fit the mold, but that's not unlawful discrimination, that's in fact legal association. And the court concluded that that's exactly what was happening at Redeemer. But in the course of its reasons for decision, the court did slam the federal government in its handling of the application for Canada Summer Jobs funding. And the court said that if it could be demonstrated that Redeemer was rejected specifically because of its sincerely held religious beliefs as they relate to marriage and sexual morality, that would be a significant charter violation that the government would have to answer for. Now, we couldn't demonstrate that on the balance of probabilities because the government failed to keep adequate records and failed to produce that evidence, and then the court recognized that as well. But perhaps more interestingly, in the course of its reasons, the court dealt with costs. Now, in Canada, in litigation, generally the losing party is required to pay the winning party's legal fees. And it's never 100%, it's usually what we call a partial indemnity basis, which is about 2/3. And at the federal court where this case was heard, it's even less. It's usually in the $1,500 to $2,500 range. And the court, in addressing costs, ordered that the federal government pay Redeemer University's full costs. Now, I have never in my career seen that before. I've seen what we call substantial costs, which is about 85% of the actual costs, and that's done to penalize a party for their conduct in the litigation. We did not allege that Canada acted inappropriately in the litigation, so the court was penalizing the government for something else, and we're left to speculate as to what that is, but based on the reasons they've given in relation to the potential discrimination and charter violations, I'm left to conclude that the court was sending a message to the government that you can't exclude groups because they hold religious beliefs you disagree with. So that's the good, and the good is that there was a clear message sent to the government that you can't discriminate against organizations or individuals in these public programs on the basis of their religious beliefs. But now we'll talk about the 2018 litigation involving the Pro-Life Advocacy Group. So that Pro-Life Advocacy Group is an organization called Toronto Area Right to Life. And unfortunately, they lost in their litigation. It was released after the decision in the Redeemer case. And as I said, unfortunately, they lost. And they lost because they did not only challenge the government's decision to reject their application, they challenged the government's decision to implement the abortion attestation itself. And that, in my opinion, is why they lost. I think it was a strategic mistake. They shot too high and missed. And so what the court concluded was that it was not unreasonable, and reasonable is a legal word that fits into a legal test. It was not unreasonable for the federal government to impose the abortion attestation because the legislation which permitted the federal government to operate the Canada Summer Jobs program allows the government to set funding priorities. And so by implementing the abortion attestation, the government was simply sending a funding priority. They have the discretion to determine that they want to fund or prioritize the funding of pro-choice organizations versus pro-life organizations. And that's the bad, is if the government can get away with doing that in the Canada Summer Jobs program, they're probably able to get away with doing that in other programs as well. Now, it's all going to depend on the underlying legislation that gives them the authority to determine or set up the program that they're implementing. But I don't see it as being far-fetched to assume that one day soon the government will require those organizations seeking charitable tax status to check off some kind of an attestation, either related to abortion or sexual morality or something else. It's not far-fetched, I don't think. And in fact, this government has already sent signals and messages that they're going to target pregnancy centers' charitable status. So that's step one. Step one was the Canada Summer Jobs program. Now that they've gotten the green light, quote unquote, on the abortion attestation in that context, they're moving over to the potential revocation of charitable tax status for pregnancy centers. And then if they're successful there, the next step might be for any charity, which could include churches, it could include soup kitchens, it could include Bible camps, private Christian schools. It's not unreasonable to assume that if they succeed in these progressive steps, that one day you cannot get charitable tax registration as a private school unless you're going to implement a state-sanctioned curriculum on religious or moral issues. So that's the bad. Now let's talk about the ugly. So the good, the bad, and the ugly. And the ugly is the new blasphemy. And The reason I chose that as a title is because I think what the Canada Summer Jobs case demonstrates, and other cases which I'll just tangentially refer to now, demonstrates that we are living in a state where anti-blasphemy laws exist. Now, they're not necessarily written in code, in law, and they're not necessarily going to be prosecuted by the police or the Crown prosecutors. Instead, they're understood to be blasphemy laws or anti-blasphemy laws, and they're going to be enforced by administrative bodies like a law society, like a a regulatory body, or a group of bureaucrats who are making a decision on a grant application or a charitable tax status application. So we've talked about the two Canada Summer Jobs examples. There are, of course, many others. Chris referenced Trinity Western's bid for a law school. So Redeemer University was denied its Canada Summer Jobs funding in 2018 because it would not make a pro-choice attestation. It was rejected its funding in 2019 because it held to a biblical view of marriage and sexual morality. Trinity Western was denied its law school for the same reason. It held to a biblical view of sexual morality, which is defined as being between one man and one woman in the confines of a biblical marriage. We're now seeing pregnancy centers who are pro-life and will not promote abortion potentially losing their charitable tax status. We've seen it with doctors related to COVID or the COVID vaccines. We've seen it related to people who are protesting COVID vaccination mandates. We saw it with the trucker convoy here in Ottawa recently, where they were retroactively deemed to be terrorists and criminals, and those who had supported financially to the Freedom Convoy were now having their bank accounts seized for the simple reason that they supported an anti-government view or an anti-government narrative. So we're going down a very dark road here. And Pastor Jonathan talked about, in his opening remarks, about the costs that will have to be paid for speaking the truth. And these are some of those costs. This is a real reality. This is a real danger, and we need to be alive and aware of it. So what does this mean for the broader church? Well, it means exactly what Pastor Jonathan said, that there are costs out there that we may have to pay, and we should be aware of what those costs are. We're navigating very murky and muddy waters, and so we need to know what those waters are and what the costs of going through them are. So just in the last week, I've had 2 calls that I think are relevant to this issue. I had a call from a church who recently received a phone call from somebody asking to speak to a pastor. And when the pastor got on the phone, the person on the other end of the line started to speak about being attracted to people of the same sex, and is it wrong? What does it mean? Is it sinful? And that's very dangerous these days, because the perhaps prime example of an anti-blasphemy law in Canada is Bill C-4, which outlaws conversion therapy. And conversion therapy in Bill C-4 is so vaguely and broadly defined that it can include any type of pastoral counseling or prayer or accountability between a pastor and a congregant. And so this pastor gets on the phone, and the person on the other end of the line starts asking questions about their same-sex attraction and whether it's right, wrong, whether it's sinful. And the pastor handled it quite well and winsomely. They didn't say they didn't take a moral position. They didn't say it was sinful or it was wrong. And I say that was a winsome approach because they didn't know who this person was on the other end of the line. So what they did was they just asked questions, and they asked questions like, well, what do you think? Do you think it's wrong? What do you think the Bible says? And the call ended there, and as far as we know, that's where this all ended. But the pastor got off the phone feeling very unnerved and uncomfortable, and feeling as though this was a deliberate attempt to bait them into saying something wrong and potentially a sting. So that was yesterday. Earlier this week, I got a call from a different pastor in a different church who's now facing a complaint made against the church at the CRA. And the complaint is that there are posts on Facebook supporting the trucker convoy. Now, the posts weren't made by this particular pastor. They were made by somebody with the same last name. So if we take Pastor Griffiths, for example, the post wasn't made by Jonathan Griffiths. It was made by Alberto Griffiths or somebody else Griffiths. And this person sends a letter to the CRA with a screenshot of the Facebook post with the first name scratched out and only the last name present. And they're saying that on the basis of that Facebook post, they're advocating hate and violence as a church, and they should have their charitable tax status revoked. Now, I don't think the CRA is going to take that seriously. It's clearly a fabricated complaint, but this church nevertheless has to deal with this issue now. Why? Because somebody with the same last name as the lead pastor happens to have posted something that is favorable to the trucker convoy that was in Ottawa. And so as a church, you're going to need to navigate these issues, and you're going to need to be aware of those issues. And so if you're a church that provides any kind of counseling, even if it's just premarital counseling or pastoral counseling for people struggling with sin, you should, as a church, have a counseling policy or protocol. And that policy and protocol should include things like, we do not engage in conversion therapy. Here's what we do for those kinds of issues. We may engage in a Bible study to see what the Bible says about certain activity or behavior. We will not conduct counseling with people over the phone, particularly if we don't know who these people are. So those are the kinds of things that the church needs to, the broader church and all individual churches and congregations needs to be aware of and preparing for, because it's not a matter of if you're going to be faced with a human rights complaint or a criminal charge, it's a matter of when. Now, I talked about the good from the Redeemer case. I talked about the bad from the Toronto Right to Life case. There is actually an element of good in the Toronto Right to Life case that I did want to highlight. So, Toronto Right to Life is not a openly or expressly religious organization, but the president of the organization is a committed Catholic. And although the organization does not have a religious identity, Toronto Right to Life successfully argued that the president's Catholic belief was engaged by the fact that he would have had to check that abortion attestation box. And the court accepted that argument. And as far as I know, that's the first and only time that type of argument has been accepted in Canada. We've seen those kinds of cases successfully argued in the United States, but as far as I know, that's the first time that's happened here. And I think that's quite significant because it opens up the door to private industry and private enterprise owners. So, for example, I have a case right now involving a Christian videographer who is facing a human rights complaint because she would not provide videography services for a same-sex wedding. And the Ontario Human Rights Code carves out an exception for organizations like Redeemer University, but it doesn't carve out an exception for private, for-profit corporations that don't limit their services to other Christians or other like-minded individuals. But the language that's found in the Toronto Right to Life decision might be helpful for that case, because we might be able to say that the Ontario Human Rights Code is in some way deficient because it does not protect her. So there is some good in the Toronto Right to Life case. But there is the good in that the message was sent to the government in the Redeemer case. There's the bad in the Toronto Right to Life case in that it opens the door for the government to impose these types of attestations in its general programming. And then there's the ugly, that it highlights the type of country we're living in with these anti-blasphemy laws. And so you have to be prepared as a church to navigate those muddy waters. You have to be aware of what the cost you might pay for speaking the truth is. And you want to, of course, try to limit the situations where you might have to pay that cost. And we'd be happy to help at the Acacia Group if you need help on that. That's exactly why we exist, why we were founded. And in fact, last year we wrote a small book to help churches and other parachurch organizations navigate these muddy waters. We've converted that into an ebook, and it's available on our website for free. So I invite you to go to our website, www.acaciagroup.ca. And if you didn't get that, go to the sponsors page on the Freedom Summit's website. You'll see our logo. If you click on it, it'll take you to our website, and under resources, there should be a tab for free ebook. And I invite you to download that, and don't be shy, give us a call or send us an email if there's any way we can help. Thank you.